So, good afternoon, everybody. I am Charu Mathur, an advocate on record with the Supreme Court of India and editor with EBC Learning. This webinar is brought to you by EBC Learning, which is the e-learning initiative of Eastern Book Company Group. Right. So, today with us we have Mr. Swarnendu Chatterjee. Welcome, Swarnendu.
Good morning, ma'am. Good afternoon, ma'am.
Yeah. So Swarnendu is advocate on record with Supreme Court of India. He has been associated with the chambers of late P.P. Rao sir. Thereafter, he worked with P.S. Narasimha sir, who was also ASG, former ASG. And now, in between, he worked with MAP Consultants, also another law firm. And now he's working with Luthra and Luthra. Swarnendu has wide range of knowledge dealing with the constitutional law as well as with the insolvency law. So today he will be touching upon a very sensitive issue which was to be dealt by Supreme Court even during this pandemic. It is basically the powers of governor versus the speaker of the house, and we will trace the journey how we have effectively dealt with it. We will be dealing with the leading cases on the point. And just to give you a few preliminaries about this webinar, the protocol for this, first we will be taking your queries after the presentation is done. Secondly, this is available on YouTube channel of EBC Learning, which is youtube.com/EBC Learning. And finally, you can check out our other webinars which are coming. There is a series. I'll just share my screen for the website. I would just like to give you an overview of our website also, the amount of courses, the work that we are doing for the betterment of the legal education. And idea has always been to bridge the gap between the college learning that we do, the law school learning that we do, and the practical things. So if you look at our website, we have got courses on the alternative dispute resolution. We have got courses on arbitration and mediation. Thereafter, we have got courses on competition law. And I would just like to remind you that we are running a series on competition law. It is a 3-part webinar. So yesterday we had 2-hour session. Today and tomorrow again we will be having 2-hour session. And there are some more speakers who are lined up for the competition law. Apart from that, we have done 3 courses on the consumer protection law. Now, consumer protection law, as you are aware, it has gone and there has been recent changes in the consumer protection law. The new consumer protection law is in place. And in these 3 courses, we cover all the gamut of the consumer protection right from the inception to the present amendments. Apart from that, we have contract law. We even teach you how to draft a contract law and even the course on the basis of contract law. Apart from that, we have a course on how do you enter into sports law contract. Then in criminal law, we have a fantastic course on criminology, and this is one of kind course that we have. Then we have got some information on the CLAT, etc. And then insolvency and bankruptcy, we have got 7 courses on it, and it is a path that you can take. You can learn about the essentials of insolvency, then you can go upon how to file it, then valuation aspect of it, then the various cases, and so on and so forth. And then on mergers and acquisition also we have 2 courses. And apart from that, we have got talks with the leading lawyers. The last talk with probably one of the last talk which Ram Jethmalani sir was with us, so was that of Madhav Menon sir. Apart from that, we have talked with Raju Ramchandran sir, we have talked with Tulsi sir. Then we have got talk with Salman Khurshid sir also is there, but it is not put on here. And then many more legal luminaries we are following. Now, without much ado, I will just start this.
Yeah,
Yeah. Yeah, I lost. There was some electricity problem.
mhm,
You can now start.
yeah.
I'll just share a presentation also. You can start
I'll-
in the meantime.
yeah, yeah. So, like, uh, good afternoon to all. I would like to welcome you all to this rather an interesting topic to me. I don't know how much interesting to all others, but it is very interesting to me, this topic, and it's a very sensitive issue in constitutional law, like the governor versus speaker, a constitutional conundrum. This is a very important topic. Like all of us know that our constitution is a mixed bag. Mixed bag meaning thereby it follows, like the framers of the constitution, like the constituent assembly, had taken it from various resources like US, UK. UK then had an unwritten constitution, and still it has an unwritten constitution. For UK's constitution, you will need to study Walter Bagehot. That's the best book for UK's constitution. But we had taken it from Australia, Ireland, Canada, etc., etc. Be that as it may, and our own framework is literally based on the Government of India Act. Now, the governor, the issue of the governor was first codified under Government of India Act, which is exactly the same or similar, you can say, to Article 153 of the Constitution of India, and Section 48 of the Government of India, 48 of the Government of India Act provided for governors of provincial of the various provinces, and the discretionary power of the governor was given under Section 50. Now there were various other powers given under the Government of India Act, whereby the Secretary of State had to report to the governor, and it was a mandatory procedure, etc. But under the Indian Constitution, while B.R. Ambedkar, the chairman of the Constitution of the committee, like Constituent Assembly, chairman of the president of the Constituent Assembly, said that the governor may not have certain powers under our constitution, but he
Anandu,
does.
Anandu, can you be a little louder? People are not able to hear you. We are just checking on the voice. He'll be audible soon.
You can hear me, ma'am?
Yeah, now is it fine?
You can hear. You can hear me. Can you hear me?
I think now it is better. Now it is fine. You can continue.
Ma'am, you can hear me?
Yeah, I can hear you.
Okay.
All good.
So,
All good.
okay, okay. So, what I was saying was that the governor's powers, the discretionary power, was vested under Section 50 of the Government of India Act, 1935, which carried on to 100 Article 163 of the Indian Constitution. Now, main thing starts with a governor takes his oath under Article 159 of the Constitution of India, and he holds office under the doctrine of pleasure of the president of India, and his term and tenure can be found in Article 155 and Article 156 of the Constitution of India. Now, without wasting much time, let us straight go to the current tussle, or the tussle which is going on for a long time. Let's say 1990s, or let's say 1979, when first, well, like 1974, a case came to the Supreme Court regarding the power of the governor to appoint people under Article 233 and 235 to the lower judiciary. The Punjab Haryana High Court interpreted it saying that governor hardly has any power to do so, to appoint, but the Supreme Court said that he has the powers, and under Article 235, for appointment of lower judiciary people, it has to be done under the seal and signature of the governor of the respective state. Now let us go to read Article 163. Governor shall, no, Article 163 reads as the governor shall be advised by the Council of Ministers with the Chief Minister as the head in the exercise of his functions, save and except where the governor is empowered to use his discretionary powers by or under the Constitution or any law framed thereunder. Now, this by or under the Constitution term was interpreted in Indramani Pyarelal Devi versus W.R. Nathu in 1963, and also State of Gujarat versus Justice R.A. Mehta. Now, R.A. Mehta was a case of Lokayukta, first of all, and it said both these judgments had actually categorically said W.R. Nathu is 1963 judgment. It actually said that by or under the constitution means there should be a provision under the constitution. The constitution should actually entrust or delegate certain functions to the governor by which he can use his discretion, or there should be certain laws by which there should he acts under his discretionary power. Like, we know that the Delhi primary school and all these things, and but Delhi is a different position, it's a sui generis position, it's a lieutenant governor, the position is altogether, I'll come to that later on. Now these are certain statutes where the governor, like vice chancellors of universities or certain things, or some in some states governor acts as a lokayukta. Now then the power is completely different. Now, for using his discretionary powers by or under any law or by or under any on the constitution, his discretionary powers, like the objective material can be tested on the ambit and anvil of judicial review, but not otherwise. And discretionary power means he can act outside, like he can take his own opinion. Now, this discretionary power is not available with the president of India. Their Article 163 comes in tune with Section 50 of Government of India Act, where the governor can use his discretionary power. Now, Article 154 says it vests the governor with the executive power of the state to be exercised directly or through officers subordinate to him in accordance with the Constitution. Now, let us come to the present debate. Article 174 and 175. Article 174 and 175 is the right of the governor to summon on prorogue the legislature. And Article 175 says right of the governor to address and send messages to the House. Now question comes, why are we discussing this today? On 13th of April, Supreme Court of India delivered a very critical judgment while interpreting and like analyzing the of two high offices of the state, that is the Speaker of the Legislative Assembly and the Governor. You may find that the governors are in today's world, in today's time, are constantly trying to interfere into the organizations of the state machinery, or into the political framework of the state. Now, it started all from Harishchandra Rawat, Nabam Rabia. These cases are very well known. While governor frames an unobjective report and the Supreme Court turns it down or turns it upside down. Now, this first issue, who the office of the governor came to be interpreted in 1979, Dr. Hargovind Pant versus Raghukul Tilak, that is 1979, 3 SCC 184, if I'm correct, or 2 SCC 184. Now, Hargovind Pant says, like the governor is a EO nominee. EO nominee means he is like an umpire of the umpire, a non-political person. He's a EO nominee of the state, and he wears an umpire's hat while discharging his functions to oversee the constitutional machinery of the state. And he is neither an employee nor a servant of the central government. He has to just ensure he is a bridge between the legislature and the executive. He is actually an overseer, a father figure, let us say, like a protector, not even a protector who goes into parallel administration, because the power has been vested with the legislature, where the chief minister along with the council of ministers of the state are actually entrusted with running of the day-to-day affairs of the state. Now, you may say, sir, there is Article 167 whereby the governor may call for certain reports. Now, the governor may call for certain reports under 167, but 167 says, 167A and B says that the governor may call for certain reports from the chief minister or from the council of ministers as to the functioning, and they are obligated to give. But Article 167 does not however say that if certain information what the governor wants is not in actual consonance with what he actually wants, what he has in mind, cannot be termed as a breakdown of constitutional machinery of the state. It's an obligatory power, hardly can be interpreted as a directory power. The government cannot direct the chief minister that you come and show me what is being done. If certain report goes, obviously the governor may ask for it report, and time to time governor being a constitutional head of the state can ask or can expect a certain report. This is the fine balance between two high constitutional offices, like three high constitutional offices: the chief minister, the speaker, and the governor. The chief minister is the head of the executive government, and he also heads the executive government in the state assembly, because he's the leader. He or she is the leader of the house, and the speaker is actually the protector of the house. Like, the house is under his charge under Article 163, 166. Their governor with the government frames certain rules, the transaction of business rules we call the TBR, which is framed under Article 77 for the parliament. The Lok Sabha rules and the Rajya Sabha rules are there. So the regular transaction, the transaction of business rules of the government are there. TBRs are also there. So by that, you can see, like, allocation of portfolios are there, many such things are there, how a government can function. Those are called transaction of business rules, TBRs. Now, let us just analyze the position from here. From I have already told you about Raghukul Tilak. Now let me tell you about SR Bomai. Everybody talks about SR Bomai being the, like, Bible with respect to the powers and ambit of the governor. Now, SR Bomai was actually a case where Article 356 and its interpretation was called into question. Number one. Number two, and our the governor in several states had, without consulting the council of ministers, dislodged the government and sent a report to the union for imposition of 356 state emergency for imposing based on the governor's report. Now, the facts of the case were SR Bommai, being the CM of Karnataka between August 1988 and April 89, he led the Janata Dal government. The Janata Dal government was dismissed under using powers under Article 356 by Governor P. Venkatasubbaiah, with a copy of the resolution passed to the. He was not even given a chance to prove his majority in the House. Now this tussle comes in, whether floor test is mandatory or not. What is the timing? Let us crystallize those issues. Timing of what is a floor test, number one. Under what circumstances can a floor test be held? And when can a floor test be held? And why should a floor test be held? Now, these questions were answered by Justice B.P. Jivan Reddy, Agarwal, and Pandian and other judges who were sitting on the bench of SR Bommai, among several other issues where doctrine of common thread was also developed. The secularism was one of the basic features and the basic structures of the constitution. It was also discussed. Now, in paragraphs 391 to 395 of this case, SR Bommai, you would find a discussion, and BP Jivan Reddy obviously discusses the 5 governors report and the chief minister's report and and the Sarkaria Commission's report and all, while writing the judgment or writing the judgment of SR Bommai. And he says that when the government has lost its majority, the line is very simple. the object, first of all, whether how a legislature has to be functioned or how it has to be functioned is on the aid and advice of the council of ministers. But no, as to the resignation of certain members or functioning of certain members, it has to be on the aid and advice of council of ministers headed by the chief minister. Now, now the question comes, when the chief minister itself has lost majority, then what happens? When the chief minister itself has lost majority along with the council of ministers, he should face the house, because the Supreme Court said, see, 10th schedule was framed with an objective to stop horse trading immediately, like the bargaining powers. And there is a doctrine of collective responsibility to the house. The chief minister along with the council of ministers is collectively responsible to the functioning of the house. That is the democratic setup. We are under a quasi-federal or a federal setup, whereby the union government and the state governments are functioning under their own scope and ambit. Though you can say under article 162, and like one under article 160, article 163, so first subclause says that the governor has to act in aid and advice of the aid and advice of the council of ministers. And next, when you go to chapter 3 under this article 168, article 168 states, like the like for the union legislature, it is for president, the upper house and the lower house. But in cases of states, though it is written that it should comprise of the governor, the state assembly, which may be unicameral or bicameral in nature. Few states have MLCs or like legislative councils also, and many states don't have the legislative council. Like for Uttar Pradesh, they have legislative council. So, but under this, if we when I go on to the case laws, we'll discuss, like the governor is a mere facilitator. He doesn't have much powers under the constitution for running the house, unlike Government of India Act. He's a mere facilitator. You can get it from the discussions of Constituent Assembly debates by P.K. Sen, Durga Bai, Allah Baksh, because Allah Baksh case is very important, because it came up then because Allah Baksh was the governor of the province of Sindh, and he was dismissed by the governor at that point of time using powers under Government of India Act. Now, Allah Baksh, when he came as a participant or as a member of the Constituent Assembly, he says, like, his words were, you cannot give powers. Like I'll quote him while saying what he said. He said, like, it has the function that the governor has to fulfill as it is borne now, it is upon the members of the house, is that of a lubricator. And if I may use the expression, he is not to interfere, but he has just to smoothen the matters. This is what he had to say. And he again quoted his own experiences, and he said, I know also, and the house will remember too, that the exercise of his discretion by the governor of the province of Sindh led to the dismissal of one of the popular ministers and myself. He further said, sir, as a piece of cow dung may spoil the whole vessel of milk. This was by Allah Baksh. And PK Sen said, if there are factions, if there are different sections of the community at loggerheads with each other, it is for the governor to act more or less as a lubricator or as a cementing factor. And Durgabai said, while debating the provisions and the article, said, we wanted to introduce the governor in our constitution because we thought that an element of harmony would be there, and that institution would bring about some sort of understanding and harmony between the conflicting groups of people, if really the governor is conscious of his duties. Now, these were actually the debates when the debating relating to the powers and ambit of the governor. First, it was thought that we will have no governors. The governor office of the governor was put to vote during Constituent Assembly. But
The audio is
yes,
still a problem. People are finding it difficult to hear you. Either you come close to the mic.
okay. Now it's possible. Now
Yeah,
it's
if you just keep in mind that you have to be near mic, so
Yeah. Now
just
now the main thing which has to be remembered is that what is a scope and ambit relating to the office of the speaker. Now, Bomai had said in 1994 that if the chief minister along with the council of ministers have lost majority, and if you see, and if according to the objective report of the governor, and he has reasons to believe that the government has lost majority, and by the mere fact that the chief minister is not ready to face the house, or he's not willing to face the house, there is no other option but to call for a floor test. But for a floor test, he has to request the chief minister and the speaker of the house. He has to send a message under article 174 and article 175 that please hold a session whereby this will be the only factor, because according to me, the house has lost majority and so many members have resigned. Now resignation, now this is another issue. Resignation of members qua the power of the speaker and the governor's power to call for a trust vote. Now, over the past few years, 5 6 years, we have seen that a trust vote is generally called for while a new government is formed. We have seen in Goa, Chandravarkar case. Then we have seen in that Balasaheb Patil case, and now we have seen in we have seen in the Maharashtra case. Now the situation in the Madhya Pradesh case came as, like, the government was in power for 18 months and suddenly there were resignation of 22 people. Now the governor being and so 22 people resigned sending their resignations, and 6 were accepted, 16 were pending. Now resignations has to be accepted by the speaker under article 190 subclause 3 subclause B, and speaker has to form an inquiry as to whether it was out of free will or it was a compulsion. Now if it is of a free will, he has no other power but to accept, the speaker. And the question before the Supreme Court this time was, like, pending the decision on the resignation, can there be a call for the trust vote? Because 6 people have resigned, 6 people are still yet to have the resignations approved. So 16 are still a member of the party. That's what the chief minister of Madhya Pradesh had argued with the governor when Lalji Tandon had asked him to face the house. But he said, quoting Harish Chandra Rawat, that you have no such powers to direct me. And the speaker said, okay, I'll have it on 26th of March. But when the matter came to Supreme Court, while interpreting the provisions, said, like, when it is apparent on the face of the record and that the objective material says that the govern that so many people have resigned and there is a probability of loss of confidence of the house, then the chief then the first and foremost objective of every government should be to face the house, because it will be a death knell for the constitutional morality and the constitution if a minority government is allowed to function. And also it will be against the doctrine of collective responsibility and collective form of government and democracy also, that horse trading is also being allowed for 5 6 days. And it will be and basically it will be an antithesis to the functioning of a government. There the governor has a role to play, asking the chief minister to go and face the house, but he is no way intervening in the functioning of the speaker by saying that you have to decide the resignations now. The Supreme Court has categorically said in this Shivraj Singh Chauhan judgment, judgment dated 13th of April 2020, that the obviously this power of the discretionary power of the governor to go and face the house is based on SR Bommai. But SR Bommai also said, and this judgment also says, and Nabam Rebia also says, that it has to be on the principle of objectivity, and that objectivity can be tested by way of judicial review. And scope and ambit of judicial review is that the whether the governor has report or the governor's consideration to go and to go and face the house, to go and ask the chief minister to face the house, is actually objective or not, is whether he has actually lost the numbers or not, or whether it is just an extraneous consideration. That is only the scope of judicial review. and and you must remember, in Nabam Rebia, while and Harish Chandra Rawat, while considering those two things, scope and ambit, the court has categorically said the governor has no business to interfere into the daily functioning of the house. But it also gave the power under Article 174 and Article 175, that when the governor feels that the council of ministers headed by the chief minister has lost its confidence, then he has the power to ask the speaker, request the speaker to call for a floor test. Now here in this Madhya Pradesh case, we went a step further. How? Because the speaker had already posted it for 26th of March. Now it had to be preponed. Now we came to the question, the Supreme Court was faced with the question whether the governor has the power to prepone it and say it immediately, like overruling the speaker. Now, that is why the title, what we have chosen, is a constitutional conundrum. That is where the conundrum comes, whether the governor and the speaker are at loggerheads here. Now the Supreme Court, within the judgment, has drawn a fine line of balance. It says, like, the governor has, obviously on the principle of objectivity, has to draw its conclusion. Then the governor has in no manner trampled upon the powers of the speaker, but as a constitutional head of the state, he has definitely the power to ask the chief minister to face the house immediately, because asking him to continue and giving a leeway to continue will be an antithesis to constitutional morality, because it will lead to horse trading and it will lead to extraneous considerations. So that is why preponing of the date of the trust vote can nowhere be termed as unconstitutional. It is nowhere in conflict with SR Bommai or with Nabam Rebia. Number one, Nabam Rebia, the governor worked on extraneous considerations. Nabam Tuki government was thrown apart, and the Supreme Court, on dismissing the governor's report, put status quo ante, like the government prior to it was restored. But ultimately, later on, what happened is everybody's aware of that. The governor, the chief minister lost and the elections and so on and so forth. Now, in Maharashtra case, what happened? The first two people took oath, then they lost majority. The governor allowed the government to function like that, and on petition, the Supreme Court said, no, you go and face the house. It told Devendra Fadnavis, the Jadian chief minister, to go and face the house, and he resigned. That is exactly what happened here. Kamalnath also resigned, because, and there Yedurappa also resigned, and Balasaheb Patil. Yedurappa had also resigned at that point of time when the Kumaraswamy's government came into the power for in Bangalore, in Karnataka. Now, in Shivraj Singh Chauhan, the Supreme Court law, as I earlier said, it draws a fine line of balance. It says that governor, although has the power, but will never interfere into the speaker's powers. Speaker's powers are exactly under the 10th schedule and Article 190. But the delay in adjudicating, now this is very important, delay in adjudication or consideration of this this resignation letters can no way impede the conduct of a trust vote. And these are not interconnected, these are not even overlapping, these are separate. Even if you don't consider those 22, have the majority like that counted, and still if you don't have the majority of the house, you are bound to resign. So that is exactly what the Supreme Court said by quoting SR Bommai. Because I still remember my senior, as Charu ma'am had introduced me by saying that I was junior to Mr. Rao. Mr. Rao had argued that case in 1994 along with several other councils, and his doctrine of common thread and this doctrine of collective responsibility was upheld by the Supreme Court by Justice Jeevan Reddy, while saying that the functioning of the House, it is in para 391 or 395, I don't distinctly remember, but it is there, that the governor wears the umpire's hat, and in nowhere it can be said that function whether the government has lost its majority or not has to be decided within the four walls of the legislature. It cannot be decided within the four walls of the Rashtrapati Bhavan or the Raj Bhavan. This was exactly the line which was quoted. And here also Justice Chandrachud, while writing a fine judgment and striking the balance, has said, like, the governor had the power to advance the floor test. By that, he protected the constitution. He acts as a protector of the constitution, as a constitutional head of the state. He did no wrong by asking the chief minister to face the house. Thereby, there was no unconstitutional act or extraneous factors as pointed out by the other side. But there is a there, now let us come to the debate. What happens now? This judgment is like a double-edged sword. Let us critically analyze this. It is like a double-edged sword. Why I say it's a double-edged sword? Because the governor forms a report. We are seeing daily in different states which are ruled by different political parties rather than the political party at the center. Now executive government, now the functioning of the executive government depends on the political party. Now the governors in those states,
Yeah. Yeah, so Nindu, can you hear us? Nindu, are you there? I think we have lost the connection. Looks like there is. Yeah, so Nindu will join us again. In the meantime, I'll just take you ahead. So you have heard about the provisions regarding the governor as well as the speaker. So before, yes, Swarnendu, are you there? No, he's still not there. So that is. So as I was telling you, I would like to, as he was telling you about speaker and governor, there is one aspect that I would like you to touch upon, that is Schedule 10 of the Constitution. Now, Schedule 10 was introduced as anti-defection law, and that idea was basically that parties they don't take away their MLAs and MPs, right? So thereafter, the Schedule 10 was inserted, but now I think Schedule 10 either it needs to be modified if you want to stop this horse trading and all these things, or in the present form, it is defeating the very purpose for which it was formed. So my take on the entire thing is that the rules are there, laws are there, the interpretation court keeps on hearing these matters for days together, but hearing the end point always come down to this, that the floor test is the only means by which the majority of a party can be ascertained. There are no other means, right? And thereafter, the speaker has the power to order the floor test and conduct it. Governor can ask the speaker to conduct the floor test. Now, the problem arises the problem arises when before I continue, I want to answer Mr. Raghupati Ramachandran. Mr. Raghupati Ramchandran, we have been constantly trying to improve. I have also told the speaker to get his voice clear. He has got the mic near his, and we are trying. There is no indifference from our side. And secondly, the same recording will be available to you on the EBC learning platform as well. Yeah, I think Swarnendu is also back with us.
yeah.
Yeah. So I just started talking to them about Schedule 10, and you
Yeah,
can continue from where you have left, and
yeah,
then we'll see.
yeah. I'm extremely sorry.
No, no.
The electric connection went off. Now, let us go to let us resume our talk with respect to the double-edged sword which I was talking about, and how the how the governors can misuse can there can be a misuse of such power and misuse of such judgment. Now, this judgment says that the governor may governor may form an objective report and say that you go and face the house. Now, suppose there may be a question. Article 167A and B, you don't give a report, and therefore I construe that there is a failure of constitutional machinery, and I send a report. Now, can article failure to act under Article 170, 167, or failure to like say some governors may say, like some chief ministers have not handled the situations of this COVID-19 pandemic very well. It has been discussed. I won't take names, but it has been discussed over and again. Like a specific governor has been constantly like thrusting and giving press interviews against a particular chief minister of a state, whereby he is like he is quoting article 161, article 167, and saying that I have asked for the report, but the chief minister is using his political antenna and not giving the correct report, and so on and so forth. But but question thus remains whether he can demand a report like that. Of course, he can ask for a report, can ask whether this may and can be interpreted as shall. There remains a question. And whether the governor can act as a stooge or a person of bias. He cannot. There cannot be a bias in favor of a particular political party if certain opposition political parties rule that particular state. It cannot be used as a tool or a weapon to overthrust that government. This overthrusting had happened in Harishchandra Rawat, where the High Court, where Justice K. M. Joseph was the chief of the Uttarakhand High Court, had restored back and dismissed the 356 and set it aside, and said that the governor, that it was based on extraneous considerations, and the Supreme Court on appeal dismissed this special lift petition, like disposed of, because Harish Chandra Rawat ultimately won with confidence. So there was no question of 356 being imposed. Now, here you may say, sir, it is a question of 356. Here it was a question of trust vote. Ultimately, the same failure of constitutional machinery. When there is a failure of constitutional machinery, first you don't go for a 356. You give a chance of a trust vote. But let's say the governor says no, according to me there is a failure of breakdown of constitutional machinery, because the health position of the health hazards have not been controlled and the government has failed to do so. Therefore, I expect president's rule or the center's intervention, and the central to frame rules and laws under Article 248. Under Article 248, if I may say, that 248 gives the center a power to frame certain laws. But I will read to you what is Article 2 for 248 actually, what does actually it means. Article 248. One second, I will just connect to Article 248. Article 248 says, like, residuary powers of the legislation subject to Article 246A. Now 246A was added in 2017 when GST was introduced. It says the parliament has exclusive power to make any law with respect to any matter or not enumerated in the concurrent list or the state list. Such power should include making of any law, imposing a tax or not. Now, the power of the parliament to legislate with anything in subject matter of a state list is again enumerated under Article 249, and it shall be done in national interest. Now, COVID is obviously a national interest, but chance should first be given to a state to enact. If there is a particular law, like under 249, there is I'll give you an example. Urban Land Ceiling Act. Charu ma'am would know. Urban Land Ceiling Act land is actually a state subject. Urban Land Ceiling Act is actually framed by the parliament using this power under national interest. So obviously, if there is an existing state law on a particular health issue, then center cannot just take over or usurp the power, or cannot override it. It can just frame certain laws with national interest. It starts with, like, 249 starts with a non-obstantive clause. It says notwithstanding anything in the foregoing provisions, it starts with a non-obstante clause, minded. If the Council of the States has declared by resolution supported by not less than two-thirds members present and voting that it is necessary and expedient in national interest under 246A or otherwise, that the Parliament shall make law with respect to that state or the territory of India. A resolution shall remain in force for a period of not exceeding 1 year. And then it says, provided that if and so resolution of for the continuance and so continuance of that law and the law made by Parliament, which but for that passing of a resolution have been to the extent of a resolution an expiry of 6 months. That's what it says. Now let us examine Article 249, subclause 3. It says, a law made by the Parliament, which Parliament would not, but for passing of such a resolution under clause 1, have been competent to make, shall, to the extent of the incompetency, cease to have effect. Now, Article 249 is categorical. Now, the governor or the governors who are asking the state, asking the center to frame laws under Article 249. I got this query yesterday from a senior advocate, minded, that under what circumstances the center can invoke the power. Now, it is very clear that it is a super special majority. That's a special majority rule. Two-thirds of the state assembly has to pass a resolution that the parliament has to frame laws, or two-third of each of the legislature has to frame a resolution, and thereafter, or the resolution has to be renewed in that effect. Here, no such state has passed. Even the center has not asked for it. When the center has not asked for it, the state has not asked for it, is not giving such a resolution, and then under Article 167 you call for the report. If the chief minister or the government is giving a report, you scrutinize the report and you come to the press and you say that this is not what I know, this is against the national interest and so on and so forth, the state is not functioning. It shows bias. That is an antithesis to the law enunciated by the Supreme Court under in SR Bommai till today, Shivraj Singh Chauhan, that the governor cannot act as a biased person. The moment the governor acts as a biased person, then he becomes a political stooge and an employee of the central government. Now, this question of position of governors, if I may just is divert from the topic when I'm discussing it, let us discuss the issue of lieutenant governor in Delhi. You may see that there are lieutenant governors in Delhi and Pondicherry. These two states are sui generis, like it's a sui generis power, but that Delhi is obviously governed by Article 239 AA and the GNCTD Act, and while Pondicherry has its own own legislature and has its own act. Now, the, and administrator is appointed under Article 239. Now, 239 AA was to be interpreted by the Delhi High Court first, and by the Supreme Court later on. The Constitution Bench of the Supreme Court said the lieutenant governor under 239 AA4 cannot run a parallel administration. He has, apart from the factors mentioned therein, like land, law and order, and police. Apart from these three things, he has to act on the aid and advice of the Council of Ministers. And with respect to other two minor issues like services and all, the issue is pending before the Supreme Court. So we need not delve into that issue. But the broad issue has been covered, that LG has to act on the aid and advice of the Council of Ministers. The same thing happened when Kiran Bedi, the current LG, had gone into tussle with the chief minister of Pondicherry, saying that over governmental issues, like the Supreme Court also could not interfere, and the single judge ruled while adjudicating the issue. A single judge of the Madras High Court ruled that, following the Constitution bench of the Supreme Court, saying that the LG is bound by the aid and advice of the Council of Ministers. So aid and advice obviously has to be taken from the Council of Ministers, and the discretionary powers of the governor can only be used when the person giving it is incapacitated, or by or under any law he is to act exercise his discretionary power, or by or under the constitution he is expected to exercise his discretionary power. And mind it, article 361 protects the acts of the governor. He has immunity from that, from any criminal proceeding as such. But when he exercises a discretionary power, that discretionary power can be called into question with respect to judicial review under article 32 or under 226 of the constitution of India. So the broad outcome of the judgment and then analysis of the judgment of the Madhya Pradesh tussle is that, like, fine balance has to be maintained, and this sword has to be used in a rarest of rare circumstances where the governor feels he has to apply his mind. He cannot be a he cannot act as a literally act as an employee saying that signing authority like a notary. Like for us, like on a like lighter note, I may say, like for us advocates on record, there is a common perception going around that we are like glorified notaries of Supreme Court. It is not that so. We are actually the spinal cord of Supreme Court. It was actually mentioned. I'm actually quoting Justice Chandrachud when he delivered the lecture last year in Skora. So basically that, like when a person is not acting with objectivity, is mere signing without without his application of mind, or asking a person to face the house when clearly there is a majority just on the basis of a bias, then obviously the things are not going right. And in this political situation, this judgment has far reaching implications, whereby time will only tell us that whether governors are exercising this power given by the Supreme Court in a fair and objective manner, because the Supreme Court's judgment can no way be criticized as wrong or right. It is obviously in consonance with the law, and a fine line of balance has been drawn.
Sorry. Spanendu, before we go further, there are some queries on Schedule 10,
Yes,
10.6 and 10.7. If you can throw some light on that.
yes. 10.6 and 10.6 and 10.7, I will just refer to the constitutional provisions as such. I will just refer to it and say, because, yeah, yes. 10.6 says, decision on disqualification on the ground of defection. Now, what is defection? Now, for that, 10.6, we have to read 10.2. 10.2 says disqualification on the ground of defection, subject to the provisions of paragraph 4 and paragraph 5. Paragraph 4 is that notwithstanding anything containing in the foregoing provisions of this paragraph, suppose a person resigns, or he votes from what he ought to vote under the obligation of the whip of the party, then obviously he defects. Now going further, he has voluntarily given, subject to the provisions of paragraph 4 and 5. 4 says of a different vote rather than what was instructed by the whip of the house, and so on and so forth. And a member of the house belonging to a political party shall be disqualified for being a member of, if he has voluntarily given up the membership of a political party. Here exactly that situation happened. 22 people had resigned from the membership of the house from that political party. And they abstained from voting. So paragraph 2 says that disqualification, they defected from the political party, and it is obviously a defection. Now section 6, questions on disqualification, paragraphs like provision 6, disqualification on the ground of defection. Question arises whether a member of house, obviously the Supreme Court says in this judgment also, the speaker is the ultimate authority. Even in Balasaheb Patil also it says. In Kihata Halawan, one of the leading cases which we have studied, Kihata Halawan Supreme Court says, while striking down this bar of jurisdiction was 6 and 7. 7 was a particular question. 7 has been actually struck down in Kyoto Halawan. It was bar of judicial review. Since judicial review is one of the basic structures of the constitution, this provision, paragraph 7, was struck down. And 6, obviously the Supreme Court has upheld that the speaker has power to deal into this defection issue, but this ground of defection cannot defer the trust vote. That is what the Supreme Court said. You leave out those members, calculate the majority, and see if you have the majority. And with respect to the other portion, whether they have defected or not, whether it is voluntary or not, it has to be governed with the enunciation of law in Bala Saheb Patel.
So, do you think the Schedule 10, I mean, the basically the purpose for which it was incorporated, it has lost? Anti-defection law is now more bothersome than in preserving the democracy.
The basic framework, we know the Kyoto Holowan judgment, ma'am.
Hmm.
Intention behind intention of the parliament in enacting the 10th schedule was to preserve horse trading, like was to go against horse trading. The horse trading shall not be allowed. Now this defection with the if a member votes against his political whip, his vote won't be considered, and he will be considered to be defected, and he will be and he shall be removed for the rest of the term of the house. So this is under paragraph 10. This is under schedule 10. Now, to say that it is just a black letter law in today's world, because you see, people are resigning, the speaker sets over the resignation, and people coming directly to Supreme Court to get an adjudication of the adjudication. Now 10th schedule ha, ha, is rather is rather coming to the rescue of people toppling the government rather than people who are actually trying to save the government. This is because when the judicial review, ultimately what happens, this judgment, the order which was given on 19th of March, it was not carried out because next day the chief minister resigned, so trust vote was not even a question. But the judgment strikes a fine line of balance. But as a pertinent question, if I may answer, this 10th schedule, obviously it was armed with to prevent anti defection, but it has, like, I would not say it has fully failed to prevent defection, but in today's world, in today's political scenario, horse trading is pretty much prevalent, and it has somewhat failed and somewhat succeeded. In some cases it has somewhat succeeded, and in some cases it has subsequently failed to hold the ground. Yes.
Right. So we will be getting these cases irrespective of how many judicial precedents
Yes.
we have. Uh, right. So just last few parting words, if you want to give to our participants, especially if they have learned the how if they work in the chamber of some senior and they have to assist in preparing constitutional cases, how what should be their approach?
Ma'am, there is a question from some one of the 10th schedule. If I'm
Okay, on 10th schedule, we'll answer that first.
Yeah,
So
yeah.
he's asking, is there is since the 10th schedule is inadequate, what is the better manner of preventing horse trading?
There is the better manner is to go for, obviously ask for a trust vote. 10th
As for
schedule
a
trust vote,
hmm.
that is under the judicial precedent of SR Bomai, which is absolutely known as the Bible. Now 10th schedule does not say that you have to ask for a trust vote. That is nowhere written. If collective it is a deduced term, like collective responsibility, and interpreting the term of collective responsibility, article 163 and article 174 and 175 of the constitution. For the state assemblies, we can say that, well, a motion, these are different type of motion or vote of confidence which are there in the TBRs or in the rules of business of the house. Like whether the confidence is there, it's a motion, like a cut motion, question r, it's a motion, no confidence motion, or it's a other term for trust vote. Okay, 10th schedule prevents horse trading and defection. It does not specify for a trust vote. Now obviously the question becomes pertinent, because if a person defects, and for that defection, for extraneous factors he defects, the members defect, and and the position of the confidence of the council of ministers headed by the chief minister is lost. Now Supreme Court or the judiciary, rather than the parliament, might frame should frame come up with a law at this juncture, how to deal with such issues of extraneous considerations. Because as the Supreme Court has said in this MP judgment, that that issue is separate and trust vote is separate. Now, once trust vote happens, the government is out of power. Now, whether they have asked for certain things or not, now here the Narsimha Rao judgment becomes important. JMM bribery case or the cash for vote, even Rajaram Pal case becomes important. Like money for asking questions, money for for extra for defecting, money for certain things. Now these things has to be, like Narsimha Rao has correctly said, it is the speaker who has to take a decision. And that speaker, here the conundrum comes into the picture again. Like the speaker first has to, ideally the speaker first has to decide expeditiously whether it is a voluntary resignation or not. So therefore schedule 10 should be taken into consideration first, then to go for the like without wasting any time. Like that, if the trust vote is fixed for, let's say, after 2 days. Now 2 days cannot be said within 24 hours, let's say 24 hours. Now the resignation, let's calculate a timeline. Resignation comes today, and as a governor I get the report at 4 o'clock today that there has been a resignation of 25 members by, and if I consider 25 members to be mine, and we deduct 25 members, then the chief minister has lost its majority. So what do I do then? I would send a message under Article 174 and 175 for a trust vote and request the chief minister to go and face the house for a confidence motion and tell the speaker to conduct that 1 point agenda. Now, as a speaker, I have all the machinery to decide on those 16 resignations. I have to call them up by video conferencing or by teleconferencing or face to face, that why have you resigned, and objective material. It is a task, but it can be completed within 24 hours or completed given the task. Now, if even one person or even majority of the 16, like 8 persons, are found on extraneous consideration, then the report of the speaker can be placed before the court saying that, see, they have resigned on extraneous considerations, so they face defection. But again, defection, the court will again come to the conclusion, now they have defected, now their action will be under 10th schedule, but you have lost your majority. Now you can, but this is actually forcing a democracy to break down.
Okay. So, see, there are two questions that I would like to ask you. One on the preparation of cases, and a part of that would be how to read SR Bowman. It is so confusing the way judgment is written with the multiple opinions.
Yes.
If you can just,
First of all, ma'am, while reading SR Momai, one should forget about the head notes. Now, this is a common rule which I'm telling for all listeners over here and everybody. Like, forget head notes. Head notes are necessary only when you prepare for your cases for arguments. While reading a judgment, if you want to know the law, forget head notes. Head notes are publisher's note. These are not prepared by the judges. Whether it's SCR or SCC, forget about it. Now, while reading SR Bomai, now there are several concurring opinions, majority opinion, and dissenting opinions. Now, first of all, see the issues. Go the facts part. You will read like history. Then go on to the issues. Like there is a paragraph dealing with the questions which they have formulated. Bench, 9 judge bench, because it got referred. It is not like one day out of the blue it was listed before 9 judge. We know as AORs that how matters are referred to 9 judges bench. Now this this matter, when you read, you first culminate the issues, then you first read the majority and try to majority judgment on those issues. And specifically, if you are reading on 356 or doctrine of common thread, read what doctrine of common thread according to all the majority and the concurring opinions. Then on the doctrine of common thread, what was the opinion of the dissenting judges? If you break down the case issue wise, then it will be much easier. And then this trust vote issue, then then this issue relating to secularism. There are 3-4 ratios of the judgment, because Bomai lays down three in majority, three things: doctrine of common thread, like secular, it's intertwined with the doctrine of secularism. It says secularism runs as a common thread in the constitution, because so SR Bommai, if we remember, it was an aftermath of the Babri Masjid demolition in 1992. This case came up in 1994, and Ismail Faruqi was decided also in 1994, where Supreme Court at that point of now the dispute was settled in 1994 when Ismail Faruqi came as a presidential reference. Also, Supreme Court had declined at that point of time to answer that question. But here, that this when you are reading SR Bommai, or rather than any big judgment, first identify the issues and read majority and conquering. Then once those issues are over, majority and conquering you have read, so majority and conquering will be basically on the same lines, only the lines are added. Conquering means it is an additional opinion. What is, like, if I may add to Charu ma'am's opinion, that is a conquering opinion of mine. But if you want to read a dissenting opinion on the same issue, read the dissenting opinion along with the majority opinion, like how they have dissented. Like, while you break it down issue wise, it becomes much easier to read. And Bommai will be remembered, that Bommai can be remembered. Don't try to memorize judgments. Identify issue wise what the ratio is. That's all.
Right. So I think with this we come to the end of our session. Thank you, Swarnendu, and thank you all our viewers and listeners.
Like, for this session, like, if I may extend my thanks to E- obviously EBC is always there, and my two researchers are there, who are who are all who are there on this webinar also. Two researchers of mine, one is Shohini and one is Nandini. Two researchers were there, and they have helped me with the research material and the material, and supporting me with the research.
That's nice of you always to acknowledge people who work with you.
Yeah.
I really appreciate this one quality of yours. Like even when we are doing matters, you always give credit to your interns, even interns who are
Yes.
working.
Yes.
That's very nice.
Yes.
So thank you all. And to this evening we are having our second session on competition law. Just for our viewers, I would just like to tell you that we are running 3 days series on competition law. It's a 2 hour series for 3 days. So in total 6 hours from one of our speakers, again from Luthra and Partners now as it is called. We are having a series on competition law. So do tune in to listen to him, because that series we won't be telecasting on YouTube, right? So thank you. Have a safe day.